Christmas. All right. I would like to call our meeting to order and would like to entertain a motion to approve the agenda that everybody has received.
I motion to approve the agenda and begin the meeting.
Second.
All in favor, say aye.
Aye.
Agenda approved. Then we have had an opportunity to look over the minutes, which were just a couple pages of our last meeting of August 30. Like to entertain a motion, unless there are any changes, a motion to approve those minutes.
I'll make a motion to approve minutes.
Second.
All in favor, say aye.
Aye.
Minutes approved. Any public comments? Nope. All right. Then we go to, make sure I do this right. There's new rules. To our new business on the agenda, which I will start with like to entertain a motion to open the evidentiary hearing.
I'll make a motion. I second.
All in favor, say aye.
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 The variance case is VAR 20-06, John and Elizabeth Slasky, variance request from 154-047 D6, front yard setbacks in Mills River low density residential MR30 for lot 47, the farms at Mills River. Now I gotta read a long story. This is a quasi-judicial evidentiary hearing. That means it is like a court hearing. North Carolina state law sets specific procedures and rules concerning how this board must make its decisions. These rules are different from other type of land use decisions like rezoning cases. The board's discretion is limited. The board must base its decision only upon competent, material, relevant, and substantial evidence in the record. A quasi-judicial decision is not a popularity contest where opinions are considered. It is a decision constrained by the standards in the Mills River Code of Ordinances and based on the facts presented. If you will be speaking, please focus on the facts and ordinance standards and not personal preference or opinion. Participation in this hearing is limited. This meeting is open to the public. Everyone is welcome to watch. Parties with standing have the right to participate fully in the hearing. Parties may represent evidence, call witnesses, and make legal arguments. Parties are limited to the applicant, the town of Mills River, and individuals who can prove they will suffer special damages as a result of this decision. Other individuals may serve as witnesses when called on by the board. Witness testimony should be limited to facts and not opinions. General public comment is not permitted during the hearing. All witnesses must swear or affirm their testimony. In one moment, the clerk will administer oaths for all individuals who intend to act as a witness or provide testimony. Next, we would like to recognize any person wishing to petition the board to act as a party with standing. If you, let's see, anybody else beside the applicant?
No, it's just
No.
it's just Mr. Slasky and myself.
Okay, so our fearless clerk will swear in those to present evidence. Thank you. Next, we would like to recognize our planning and zoning staff to present the case and enter preliminary materials into the record.
Just because I want to make sure we didn't skip. Did any board members disclose personal knowledge about this number 4?
Anybody?
Okay,
Nope, nope, nope,
great.
no,
I thought so. Just
sorry, thank you.
All right, good evening, everyone. Thanks for making time tonight for this special called Board of Adjustment meeting for variance case 2206. We've heard a couple of these before. So this is for lot 47 in the Farm at Mills River subdivision. No address currently assigned, but it's on Majestic Ridge Road. Little background on it, they're asking for a 15-foot variance from the front yard setback requirement, which traditionally is 60 feet for the MR30 zoning district. So if this variance were granted, that would change the front yard setback to 45 feet. Going through the history of the application and the submittal. So Mr. Slasky submitted the application on November 10th with all the supporting documents. And then we had to schedule this special meeting just because of conflicts with the holidays and constraints to public notice requirements because some of the papers in the area did not print for a couple of weeks. If you look through the application and the materials provided by the applicant, just a quick summary, the applicant claims unnecessary hardship due to 3 mature maple trees on the property that are within the building footprint of the proposed home. If the proposed home adheres to the 60-foot front yard setback requirement as the code requires today. Moving the home forward with the variance to a 45-foot front yard setback will allow 2 of these mature trees to be saved. And then I believe we heard this with a previous case. This is one of the 5 or 7 lots that has the Duke Energy power lines running through the rear, which is about a 30-foot wide, basically Duke Energy maintenance easement under the power lines that the applicant claims limits the use of the rear yard. And so again, moving the home 15 feet forward through the variance will allow greater use of the rear yard of the applicant. And then I did include here that a similar request specifically just for the Duke Energy power line easement was granted by this board for VAR 2204 for lot 49. So just 2 lots over from this one on May 10th of 2022. That's basically the conclusion of my summary. The evidentiary hearing was properly noticed. We mailed public notice letters on December 29th and a public notice sign went up the same day, and then legal advertisements again ran after the holidays due to the newspapers being closed. So they ran on January 4th and January 11th. We have the variance requirements here, the 4 standards. The application is in your packet as attachment A. We have the zoning ordinance excerpt as attachment B. An aerial view of lot 47. I don't believe the parcel was highlighted. This was supplied by the applicant. We have the Farm at Mills River subdivision plat, and this is not the entire subdivision. They've been platting certain sections of the subdivision and specific lots individually. So the subdivision plat that is attached is the particular one where this parcel was created, but it does show the overhead electrical. And then the applicant provided 2 site plan scenarios showing the mature trees, one adhering to the 60-foot front yard setback and one adhering to a 45-foot front yard setback if the variance were to be granted. And then the certificate of mailing of public notice letters is included in attachment F. That's the conclusion of my summary.
Thank you. Then next, we would like to recognize the applicants and basically ask them if they agree or have any objections to the exhibits that are just made by the planning and zoning official.
Since then, we've actually gone and listed an arborist to look at the trees, make sure that what we're requesting, the trees are going to fall down. And they came back with clean bills of health, in essence, along with some guidelines about putting temporary fencing around the construction to change the integrity of the roots, and watch that we can drip lines that we sent them basically the same stuff that you have with the 2 folders of the 50-foot. So there's from the street. And that-
Okay, if you can stay at the podium for a second, are there any questions from our board for the town planner on this earlier presentation of the exhibits or explanation of the exhibits?
No, my only one would be, you don't see any objection or issues to granting the variance would cause any concerns that perhaps we would not be aware of, or
No,
thank you.
I've received no public comment of any time, and letters are mailed to adjacent neighbors, and then again, the public notice sign is up there as well.
Any questions for the applicant at this time?
I'd like to ask Mr. Malachek a question real quick. Are we allowed to look at neighboring properties and see, for instance, I don't have a ruler, I don't have a scale on this picture, but it appears the neighboring home that's already constructed is less than 60 feet from the road. Is that a factor that can be taken into account by us if we're,
It's really at the discretion of the board, but normally with variance procedures like this, it's considering the
Mhm.
specific application for this property. Even, I referenced the previous case that was similar, but in this circumstance, this property has mature trees, which is a factor that was not part of the previous case. So again, each case should be looked at on its own.
sure.
But I'd be happy to pull up the GIS if we want to take a closer look at the aerial view.
But I think the decision has to be based on the specific four questions or statements.
Yes, sir. I was just thinking, to myself, well, would that create something totally unusual out there? In this case, maybe it doesn't, if the adjoining.
I understand. So there are other homes that have been granted variance setbacks on that street. So this will not be the only home that is positioned in that way. Correct.
Range in size for a total of 20, but they're 34 inch to 34 inch wide.
Diameter.
They're, two of them double from back.
So there's only looking at your diagram here and looking at with variance, the with variance, the tree can be saved. So let's call that tree number one back here.
Furthest back up.
Okay. So trees 2 and 3 are gonna go.
No, should be three should be okay. As well.
The furthest, closest to the tree.
road, closest to the road and closest to the tower.
So it's just, if you get the variance, it's the little one on the point, on the corner of
On
the
the
house.
corner of the house, it's just too close. Without moving the house up another 15 feet without.
Yeah. but then that one- right.
It would, yeah.
And if you don't get the variance, it's still tree number 3
Right.
gets to stay.
Yes, yeah, because it's actually, when we purchased the lot, we did not know. It was survey, we didn't know it was that building envelope, we had survey prior to. And rectangle, 30 feet from the property line. Number 1, 2, reserve view, all within that building. closest to the road, we also specifically had our house plan narrowed. Definitely see that.
Other questions? We don't have anybody else presenting. All right, thank you. You may be seated. We may come up with something. Preliminary discussion. We can still ask input from any party represented here. Any thoughts, ideas? No? That's easy. Then I would like to entertain a motion to close the evidence portion of this hearing.
So move. I'll second.
All in favor, say aye.
Aye.
Thank you. Then next is our deliberation of the board, considering all the factors set out in the ordinance. And then we have to end up with the findings of fact and the different motions to address the 4 separate statements that we all know. Any discussion, any concerns, any,
I think it's fairly straightforward. Gentlemen, if you care to maintain what you can of the put your trees even around here, but we have a bunch of them. Your trees are still pretty nice. Especially in the new neighborhood.
Yes, I agree. I think that's a very good thing to do. Mature trees, it takes forever for them to mature. It takes, I'm very impatient, so I think that's a good thing to observe.
then I would propose that we entertain some motions to address the 4 requirements to issue this variance. And on page 2 of the application, you have them listed, and maybe there's another piece where. Yeah, there's another, a variance decision tool. That's a new one. Yeah. So, and you all have a copy of that. Whatever the law is, states that all 4 of these standards must be shown for a variance to be approved.
Sorry, one quick reminder, when you're going through these, you're basically creating the findings of fact. And those need to be tied to a piece of evidence. So just as you go through them, make sure you tie it back to something that was presented either in hard copy form or testimony, please. Thank you.
Thank you.
Do we need to find facts such as that it was properly noticed? Do we need to?
No,
That's at
Okay.
the discretion of the board.
Okay.
it's just those 4
You said-
unnecessary hardship and conditions, etc. Yep. I'm ready.
Mr. Chair, I have a motion.
Go ahead.
My motion is that, based on the testimony of the applicant, pictures, slide, by the town and the applicant, I find it would be an unnecessary hardship. Unnecessary hardship would result from the strict application of the ordinance due to the removal of the mature trees and the fact that the new power line affects the size of the backyard. And no fault of their own. Probably strict application would help unnecessary hardship.
I will second.
All Do you have the motion? Okay,
Mhm.
all in favor, say aye.
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 Mr. Chair,
Yes,
I'd like to make a motion.
go ahead.
I'd like to make a motion that the hardship results from conditions that are peculiar to the property. Hardships, it is not a hardship that is common to the other properties. And that hardship in particular are these trees and the power line.
I will second.
Do we have the motion? All in favor, say aye.
Aye.
Thank you.
I move that the hardship. I move that the hardship did not result from actions taken by the applicant or the property owner. The act of, in that the property was not totally surveyed at the time he bought it. The Duke power line was there, the trees were there, and he was working within what he thought was proper.
I'll second.
Do we have the motion? All in favor, say aye.
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 So now I screw this up. The requested variance is consistent with the spirit, purpose, and intent of the regulation, such that public safety is secured and substantial justice is achieved. I make a motion to approve the variance.
Do we have to add to that specifics?
First, we've not voted on the last motion.
No.
The one Heidi first made on the fourth finding has not been seconded. It needs to be voted. And yes, there should be some type of finding as to why that's being approved.
Okay, then Heidi, can you add that finding to this motion?
Chair, I.
Yeah.
I can propose my own amendment.
Go ahead.
That the requested variance is consistent with the spirit, purpose, and intent of the ordinance such as safety, secure, substantial justice is achieved in the sense that it's consistent with the mission and lore of what we try to do here in Middle River by keeping old growth. Also, sense that removing themselves further from the easement of the power line. Property is set for option.
I will second.
Do we have the motion? All in favor, say aye.
Aye.
Thank you. Then I would like to entertain a motion to approve this variance following our findings.
Make a motion that we approve this variance based on our findings.
Second.
All in favor, say aye.
Aye.
Motion approved, variance approved. And let me get back to my, we had 5 out of 5 approval for the variance. So I'd like to entertain a motion to close and adjourn our evidentiary hearing.
I move to close and adjourn the evidentiary in portion of the meeting.
I'll second.
All in favor, say aye.
Aye.
Thank you. That's it for you. I hope
Thank
that
you.
worked.
Thank y'all for being there.
And next on the agenda is our regular scheduled meeting is on February 14th. And there's something special about that day. So we want to make sure that we have a quorum Or if not, we can postpone that meeting. I can come.
I cannot, I'm scared Jeff's lying. So what happened?
No, I'm one vote, so it doesn't matter if, duty first. I hope she's not watching.
You need your wife or your board.
Oh, I definitely would pick the wife. She's put up with me for 31 years, but,
Okay.
whatever works. I mean,
You're at 3-2 right now. So even if Jim was available, we would not have a quorum. Well, we would have a quorum, we would have enough for a variance, but we'd be pushing.
Yes.
So that was after another.
At this time, we're expecting to receive a variance application, but
Uh-huh.
it has not been submitted. But I expect to receive it probably in the next 3 to 5 days.
Okay. So can we
Well-
postpone it to the next regular scheduled meeting?
You,
But that's not July.
Well, can we make it March?
They have the group.
just do it.
how about we know that we would not have enough people on February 14th.
Mhm.
If we receive the application, we will reach out with an alternate date.
So we would do it similar to what we did for this hearing tonight. When I do receive an application, and again, there's no guarantee it will come in the next 5 days, but that's what I've been told by the potential applicant. Once we get it and we've processed it, we can reach out to the board members and see when everyone's available for a special called meeting, again, if that's the board's pleasure.
Okay. That's good. The following week, I cannot. So the week of the 20th of February, I'm booked.
I've got class on Monday nights and Wednesday nights. So, at least for the semester. I'm teaching, aviation
Yeah.
over at AV Tech.
I think that's a great idea, and then we'll see if that flies.
Class.
Generally, we would try to reach in March.
All right, very good.
Do we need a motion to cancel the February 14th meeting? Is that what we're doing?
Well, was it actually, we don't have to.
Okay. Got it.
So there's no point in it.
Understood.
Well, yeah, I think it probably would be good that our regular scheduled meeting of February 14th is canceled. Do we need a motion?
I'll
Sure.
make a motion that we cancel the February 14th regularly scheduled meeting.
I'll second.
All in favor? Aye. All right. Then I would like to entertain a motion to adjourn.
Motion to adjourn.
Second.
All in favor? Aye. Thank you very much. Appreciate it. That's it.